This is the case we can't quite get to the finish line.
Two sides were $76 apart.
I did reach out to my colleague. That offer was summarily rejected. Would not take Ms. Speech's rent. 7 different occurrences.
Not payments in full.
$175 per month in late fees.
I tend to wonder how they'd suffer $175 worth of damage.
Judge, if you were to enter a judgment, your judgment would be -$1.
2 days ago, I brought you the case of a greedy landlord where Judge Middleton cut off her camera feed for smirking and laughing at the tenant. She's listening into today's hearing so she can hear just how little Judge Middleton thinks of her case. There's a lot going on here. I didn't cut out the boring math this time because it brings context for the entire hearing, during which Meg Bauer is an absolute powerhouse, as usual, and the plaintiff's attorney is a petulant bastard, as usual. Let's roll, nerds.
All right. Miss Spike is here. She was late, but she is here. She was actually here in the courtroom with me, and now they put her in the conference room, but she's been here. This is the case we can't quite get to the finish line. This is file 252403LT. I stuck this in here knowing I had all these small claims cases pending and that it probably wouldn't fit very well, but here it is. It's set for 2:45 today. We're quite a bit behind. Meg Bauer is here on behalf of Miss Spike. Miss Spike is here. As I said, she was right here in the courtroom with me, but now she's in the conference room in case she needs to consult with her lawyer. And Mr. Landman is here, and Ms. DeCenzo, one of the owners of the park. We were close, but there were disputes about one thing or another. Defendant has been making payments into escrow. I will defer to you, Mr. Landman. What's the status here today?
Your Honor, when we were last before you, I believe that the two sides were $76 apart, based on your calculations and based on what I recall being placed into escrow. The $76 amounted to the $40 late charges for November and December, and the overage of $4 that was paid into escrow, if my memory serves me correctly.
Yes.
I think you adjourned the case to today to try to allow for a negotiated resolution rather than a final decision coming from the bench. That did not come to pass. There was a proposal made by Ms. Bauer a short time ago that required additional concessions on the part of my client and an extended timetable to pay, neither of which was acceptable. So at this point in time, from my perspective, we are waiting for a decision on the late charges for November and December.
Ms. Bauer, what's your position?
Thank you, Judge. The defense received no settlement offer from the plaintiff. So in an effort to try to get this off your docket, I did reach out to my colleague. That offer was summarily rejected, and so here we are. Ms. Speech attempted to pay her rent due on October 10th. She went up to the store to pay on October 17th. She attempted to pay on October 24th. She attempted to pay on October 31st. She attempted to pay, including November's rent, on November 4th, November 7th, and November 14th. That's 7 efforts that Ms. Speech made to pay her rent, to pay all of her rent. And the plaintiff rejected those efforts. The plaintiff is now asking you, once the plaintiff rejected those efforts, she had no option but to ask for an escrow order so that she could put her rent into the court's possession. Now the plaintiff is asking you to give it a judgment of, last time the ask was for $79.76. Today it's $76. Regardless, the plaintiff is asking you to enter a judgment of $80 in its favor, because its client, or because it would not take Ms. Speech's rent on 7 different occurrences. Ms. Speech was not late on her rent in November. She was not late on her rent in December, and she attempted to pay her rent in full on October 10th, a mere 5 days after the deadline. So, in the absence of a willingness to collaborate, Ms. Beach does object to any award of any late fees, October included, on the grounds that those clauses in the contract are unenforceable penalty clauses. The Michigan court has set out a three-part test under Roland v. Kenzie. It's a 1968 case. If a liquidated damages clause is going to be enforceable, it must satisfy 3 conditions. Parties seeking recovery must suffer real, substantial damages as a result of the breach. The damages must be uncertain, and the stipulated sum must be reasonably related to the injuries that may result from any breaches to which it is applicable. In this case, the plaintiff has been seeking $175 per month in late fees until we showed up at the first hearing when they indicated, well, we'll take $40. There is no injury to the plaintiff because Ms. Beach has been attempting to pay her entire rent plus some since October 10th, and they have been rejecting it. So we are talking about lot rent that is $440 and a late fee that is originally almost half of her lot rent. We have heard no evidence or testimony on the actual damages that the plaintiff incurred as a result of Ms. Beach attempting to make her payment on October 10th instead of October 5th. And Ms. Beach can provide testimony to support the statements that I've made, that she's actually made 7 independent trips to the store because they won't take payment elsewise, to attempt to pay her fees. She then had to contact legal aid, get legal assistance in order to get a place to pay her rent. And she's being punished. She is being punished for trying to pay her rent, trying to be a good and diligent tenant. And the plaintiff is asking you to continue punishing her and allow them to continue to pursue their frankly egregious practices of forcing tenants to pay $175 in late fees or come to court. So the defense objects to any award of late fees and asks this court to release the escrow to the plaintiff and dismiss plaintiff's claim as paid in full through December 31st.
In response, Your Honor, a couple of things.
Sure.
Firstly, Ms. Bauer concedes that her client paid late in October. So the issue of an October late charge should not be in dispute. Secondly, the payments that were attempted by the tenant were not payments in full. The lease that was signed by the tenant, agreed to by the tenant, explicitly provided for a $175 monthly late fee. Under Roria versus Continental Insurance, the Michigan Supreme Court has held and it's been cited over and over and over again that the words of a contract are to be given their plain meaning.
That's not a landlord-tenant case.
I agree. It's not a landlord-tenant
Summary
case.
Proceedings Act. It's not under the Landlord-Tenant Relationship Act. And
But a lease is Your Honor, case law is clear that a lease is a contract. So the bottom line is that your policy is, at least until January 1, was $40 a month for late fees. And my client changed its policy based on what you have indicated would be awarded. My client will change its policy again based now on your indication that as of January 1st, $50 a month for late fee is what the court will award. So there has not been an evidentiary hearing on the issue of penalty versus necessity. Ms. Bauer suggests to you that there's no evidence, but there hasn't been an evidentiary proceeding that has been scheduled by the court to address that. I'm assuming such an evidentiary proceeding would be in person since the court prefers it that way. As far as the amount, Ms. Bauer may be correct. It may have been $79.76 versus $76. It depends on the amount that's been paid into escrow. I don't know the date that the November payment was made into escrow, except I'm sure that it was after November 19th, which was when the escrow order was entered. And again, we've already discussed ex parte versus having a hearing on the issue, and I'm not going to revisit that. It should not have been entered ex parte, in my opinion. But the payment was made late in November, even into escrow. The motion for escrow was filed after November 5th. I believe it was filed November 14th. December's payment, I don't know when it was made into escrow. If it was made into escrow after the 5th, certainly it was made late. But again, the bottom line on the whole thing is that the October payment was made late. It wasn't paid in full. The offered payments in November were made late because they didn't include any late fees at all. And then it was paid late into escrow. So my client's position is unchanged, and I believe Ms. Bauer's argument is flawed.
She stated one of the quintessential cases on liquidated damage. And the law is not clear, but it's supposed to be related to something, some loss. For those of you who are waiting for your small claims case, I apologize. I'm the judge and I stuck this in here. We're fighting about $76, and so far we spent several hours fighting about $76 as it boils down to it. We can't quite get where we need to be. My hope was that they would reach a settlement and this would take 2 minutes instead of an hour. What they're proposing is an all-day hearing regarding how much the damages actually are. How much does the plaintiff suffer from the late fee being late? And as I stated, I didn't think I could find a judge in the state that would allow a $170 a month late fee. And I don't appear everywhere. Mr. Landman does. He said apparently some judges would. There are some judges that allow no late fees. I started at 25, went to 40. I'm at 50. This is lot rent, not even the apartment. So I tend to wonder how they'd suffer $175 worth of damage for not paying their lot rent. But I'm not going to expend any more emotional capital on this. You guys can appeal me over $70. I'm going to take out the October and November, the November and December late fee. October's payment was late. First attempted payment was October 10th. I'm going to take out $80. There was a $4 overage. And I believe there's enough money in escrow to pay the arrearage. It was a 79.76 difference is what the difference was. We had $1,659 in rent and $1,580 in escrow. I will take out 2 late fees. So that leaves us 20, that leaves us 4 cents off. Through December.
Your Honor, the total also doesn't include the $170.05 in court costs.
Yes, it costs.
Right.
Which is $1,829. So I'm going to take $1,659.76 minus 80.
Judge, you said 1,000.
1,659.76.
Minus.
That equals 1,579. She has 1,580 in escrow. But there are court costs of $170.05.
Judge, if you were to enter a judgment on the judgment amount, her judgment would be negative $1.
That's incorrect.
You're asking her to pay $170 filing fee and court costs on a $1 judgment in her favor.
No, the judgment amount is 1579.76. The costs are 170.05 for a total of 1749.81. And then the judgment would provide that the amount being held in escrow should be paid to the plaintiff, which would reduce the judgment balance.
Correct.
I would also like to point to the plaintiff's lease. Since my colleague would like to hold on to the terms of the contract, paragraph 34 addresses attorney's fees. As we know, attorney's fees themselves are not awardable under the statute except as set by statute, so those are in violation of the Truth in Renting Act. And the contract provides for a 15% fee. So the tenant agrees to pay all costs of collection, including 15% of the sum collected as attorney's fees. So 15% of the amount you're about to award
is far more than the statutory attorney fee of $75.
Except that she has paid her rent into escrow. She has paid November on time. She paid to the extent that she was able to. She paid including a $50 late fee. On November 4th, she paid $50 for October's late fee, plus her November rent, but it was still rejected. And then she paid December into escrow on December 4th. On November 4th, Ms. Speech attempted to pay $1,078 to the plaintiff, and the plaintiff rejected it. That is $50 more than the plaintiff was entitled to for November through November 30th.
Again, Your Honor, I would state that the $75 is permissible by statute and it is appropriate in this instance.
I agree. Even though it was a negative $1, there was a original late payment which instituted the case. So plaintiffs entitled to their court costs. Escrow funds may be released
Judge,
to the plaintiff.
will you extend Ms. Speech's redemption period based on the fact that $170 in costs and fees is 50% of her rent? This award of court costs and attorney's fees is very likely, if exclusively court costs and attorney's fees, is very likely to render her homeless if there's not an extended redemption period.
Your Honor, I believe that January 8th should be plenty of time for Ms. Speech to come up with this amount. January's rent, of course, is due on the 1st.
And Judge,
Yes.
we are not fighting over $80 simply on principle, but as you know, the demographic of clients that I represent, every dollar makes a difference. So we're not trying to be difficult. What seems like a couple of meals for one person is a substantial portion of that individual's entire monthly budget.
As I indicated, this matter's we've been at this since October. I think they are entitled to their court costs. They were compelled to file the case. We did try to whittle out as much as we could. We tried to spend a lot of time doing it. That's my order. $1,579 through December, 170.05, and cause for a total of $1,749.81. The escrow funds of $1,580 may be released to the plaintiff. So you owe $169.05, Ms. Speech, to be current by January the 8th. Mr. Lamon, if you would send me an order.
Your Honor, I will do that.
Judge,
Yes.
advice, this case could have been mitigated if the law firm seeking to collect these fees had advised its client of your policy and what it would accept in fees. And this will subject Ms. Speech to the perpetual late fee cycle because they will not accept her money unless it also includes rent for all of January at the same time. And so she will late again.
And that's an issue. If it's a non-payment of rent case, they have to accept payment of the rent. They don't they can't only accept payment in full. And so that's an issue they may need to deal with.
This is a non-payment of rent case, and they have rejected.
Yes, I understand.
Okay.
I don't have any more time to spend on this. I've got 10 litigants in 5 cases waiting for their small claims cases. So I've made my ruling. Mr. Landman can submit an order. Miss Speech, I keep mispronouncing your name, I'm sorry. You owe the court costs minus $1. You've done an excellent job of paying the money into escrow. That money will go toward your rent. Heaven forbid we could have a hearing one day to determine what their actual liquidated damages are. They're not $175, but I try to be consistent across the board, and we'll go to 50 as of January 1st. All right, that completes this case. Miss Speech, I don't have an order to give you because I don't have one from Mr. Landman yet, but he's going to email me one. We'll get one to you as soon as we can.
Judge, I'd also like to state for the record that it was represented at the last hearing that all of the tenants in the park were notified of a change in the policy, and I've spoken with multiple tenants that received no notice of such change. I understand that you are done with this
We
case.
haven't had a case yet, so I guess we'll see. We may need a hearing. It would take a day to figure out what their actual liquidated damages are, but we don't have time to address that right now. All right, thank you all.
All due respect,
Your
Judge,
Honor.
that is not my client's fault.
All right, thank you. All right, we'll see where this goes. Miss Speech, I hope you can make that. Keep your tenancy and your trailer.
I can pay the rent. I'm not going to be able to pay the $170 court cost by January 1st. I mean, come on, I'm a cashier. I can't.
Then I don't have an answer for you. They're entitled to those fees. All right.